So again, thank you very much. This talk is going to be about contracts, ERPA's main emission reduction purchase agreements. They're essentially international contracts, most of them, in the sense that you have the seller located in one place, the buyer located in another place, and normally you have a different governing law, which is also not from the buyer's jurisdiction, neither from the seller's jurisdiction. Okay? To give a bit of context, perhaps repeating quickly a little bit of what has been said by Leslie is, well, ERPAs are a forward purchase and sale agreement. What does that mean? It means that buyers and sellers, they negotiate something today, but the settlement, the delivery of the emission reductions and the purchase and the payment for those emission reductions will take place sometime in the future. So even though the agreement is already signed, the settlement of their agreement will take place somewhere in the future. Most of the things I'm going to say today are about ERPAs in general, but I will try to give you the perspective of the seller, of the country as a seller. Sometimes the project developer, but also the country as the position of the seller here. And just for you to understand the way those contracts have evolved through time, they were mainly designed by buyers at a time where the market was a market for buyers, essentially. So a lot of the things and clauses there have been adjusted through time in order to make things more balanced for both sellers and buyers. So right now we can say they're not so buyer-oriented anymore, and more the sellers are getting to understand how those contracts work and are becoming in a better position to negotiate them. Just to give a glimpse of some famous examples of ERPA transactions that have already been executed out there. The Walt Disney Company have bought REDD+ credits from the Peruvian government and Conservation International. We all know that Costa Rica is now negotiating with the World Bank. I think they are still at the stage of a term sheet, and I will explain soon what a term sheet is. In Brazil, we recently concluded what is one of the first kind of transactions involving an indigenous tribe in Brazil. That's the Surui tribe, and they negotiated successfully their credits, their REDD+ credits, with a cosmetics company in Brazil called Natura, which was sort of a landmark for Brazil because there was always a lot of discussion as to whether, and that might happen in other countries as well, as to whether indigenous people have the legal personality and the legal capacity to enter into those transactions first, and whether they are actually the owner of those emission reductions in their lands. So this is a particular question that happens in Brazil. It might be the case in other countries as well. Another example is from a project developer in Kenya that sold its REDD+ assets, emission reductions or credits, to Eneco, which is a Dutch energy provider. And why all these companies and institutions are buying those credits? For, well, many reasons. Some development banks do that to stimulate the market and create a market in REDD+ and payment for ecosystem services. Some, like Natura, for instance, they are not following any compliance regime, but they have their own carbon neutral program. We have entities that look into buying credits that potentially can access future compliance regimes. As we have seen in the previous slides, there are a number of cap and trade regimes in operation, some of them still being designed. California is one case that might accept REDD credits from jurisdictions, for instance. So there is some hope, and some experts, some buyers believe that they can buy in for a cheaper price now and then get some, some better price when those credits are actually accepted in one of those regimes. Also, banks and traders are interested in that. They were much more interested before when the market with the CDM and so on was actually going better. They were actually doing a lot of trading. So banks were very much involved in it. They would buy into what we call back-to-back transactions. So they buy for their client, from their clients, and then they sell it back to, let's say, an European entity which has an obligation, would have an obligation in the European trading scheme. So in that transaction, they would profit by arbitrating the price. What those IRPAs entail? So as I said, they are forward agreement, right? They are international contract, deliver and pay for emission reductions. They could be either a very long-term contract, then we'll be talking depending on the length and the term of the project, perhaps 10, 15, or even more, 20 years. Or they now may be something more of almost a spot deal, in the sense that in many cases the credits or the emission reductions have already been verified, or credits have already been issued, and they are ready to be delivered. And in those cases you may still have an IRPA where the buyer is willing to offtake, to buy those credits, and that might take only a few days. It's just a question of opening an account on a registry system, and then ordering that the credits be transferred to that account, and then the buyer making the payment to the bank account of the country or of the seller. So now getting to the nitty-gritty parts of the contract, which are not so pleasant for most. Steps of the transaction. So when you're negotiating an IRPA, you normally have first term sheet. Once the term sheet is negotiated, you go for the actual IRPA negotiation and signing. And if all goes according to plan, at the end you have a transaction settlement. At some point in the future, you have the transaction settlement, which is delivery of emission reductions and payment for those emission reductions delivered. Some explanations on the term sheet. The term sheet is a non-binding document. Does that mean it is useless? No, not at all. I mean, it has, first of all, some provisions in that document that are binding, right? So confidentiality is one of them, especially because of price, because of the structures you're offering within the contract that needs to remain confidential. And there is also an exclusivity arrangement there, which says that the seller is not able to negotiate that tranche or that volume of emission reductions. It is negotiating with that buyer with anyone else. And that normally lasts, let's say, for 1 to 3 months. That's more or less the time. It may take more, but that's more or less the time that the parties need to negotiate the actual IRPA. Some things to keep in mind. While the term sheet is originally intended to be a summary of commercial terms, it happens more and more, specifically when buyers put up those term sheets for sellers, that they will actually replicate everything that they want to see in the IRPA in the term sheet. So even though not buying, you see term sheets that are as long as IRPAs, actually, sometimes. And what it does is, while those terms are not binding, it will set the course for negotiation. So once you accept that, then when you move to negotiate the IRPA, it will be very difficult for a country to simply say, okay, now I change my mind, and whatever I had there in the term sheet, I don't think it's going to fit me anymore, and I want something else. You're going to get a lot of resistance when you do that. So you have to pay attention when doing this term sheet on how much information you want there. And if you start negotiating that, just imagine that you're actually negotiating the IRPA right there. Because changing the provisions afterwards legally is possible. But in terms of dynamics of negotiation, that will be very hard. When you get to the actual IRPA, to the actual contract, so then you know that it's binding. So you know that you have a commitment to deliver something at a future date. And this something which is, you know, it will have to be established very clearly in the contract. What is this object that you're delivering? And we will discuss this just in the next slide. It's also common that before you sign the IRPA, or even during the first part of the IRPA that we call conditions precedent, that would also be in the next slide, that you have performed, well, the buyer has performed a due diligence over the program and the government that is managing that program, but also the government has performed a due diligence on who is the buyer. You know, is this buyer financially capable of taking on this commitment? Is it able to pay for it? Is it willing to cooperate with this process, being a long-term contract? So all those issues are going to be dealt with under the due diligence. And finally, you get to the transaction settlement that we'll also discuss further ahead. Okay, so when you open up a contract, an IRPA, normally the first thing you see there, besides the definitions of all the terminologies you see in the contract, are the conditions precedent. So these conditions precedent actually means that, well, the contract has been signed, so the contract is in effect, but its key obligations, such as delivery and pay for those emission reductions delivered, will not kick in unless the conditions that are set out in the agreement have been performed, fulfilled, okay? And there can be a number of conditions that the parties can choose and negotiate. I have mentioned a few here that appear most commonly in those types of IRPAs. One being the evidence of title, and that is borne by the seller. That means that the seller must provide evidence that he has the title to those emission reductions. If not at that very moment, but that it will have the title at the moment that it will make the transfer to the buyer. This implies in a cost. Normally you have to hire a law firm to do that. That's, I would say, even though I'm part of a law firm, I would say that's not even necessary sometimes, because most of the countries don't have anything that actually establishes what is a carbon credit or what is an emission reduction and who has the title. So what you do is that you follow principles of civil law, of commercial law, that might apply to these types of assets, normally deemed as intangible assets. So what we suggest in this case is that you use, for sellers and for countries, that you start putting in the contract sentences such as, to the best of our knowledge and to the best of the legal interpretation we have by our advisors, those emission reductions belong, let's say, to the state, or belong to the owner of the property where the REDD+ project is taking place. So it is a way of saying, listen, we have done our homework, we have studied, and this is what we believe it is, but since we have no law, at least in civil law countries, no law is stating that, or in common law countries that we have no jurisprudence about this, we can't really say 100% that we actually own it. And that's the risk sometimes that both parties have to live with it. The second aspect is financial health and ability to pay of the buyer. This is something borne by the buyer and sort of a due diligence that the seller does on the buyer. Other types of condition precedent, for instance, the buyers normally require from sellers that they show a letter of approval or that they get their program, their REDD+ program, validated, verified, for instance. And that could be under one standard or even more than one standards. Let's say that they want, you know, a standard that looks into emission reductions only and generates credits, but also a standard that looks into social and environmental benefits. So those additional green credentials for the emission reduction. One case that I have participated with the indigenous tribe is that the buyer wanted to see that the particular indigenous tribe authority, which by law has no competence to approve this, but they wanted to see that they were informed and consulted before the ERPA could actually become effective. So this is another type of condition precedent you could see in those ERPAs. You also see, for instance, I think in the case in the FCPF, they ask for a submission of a benefit sharing plan and safeguards plan, if I'm not mistaken, also as a condition precedent. Some legal suggestions here. Those conditions, they cannot be too generic, right? They need to be specific. You need to know when they are fulfilled. You need to be able to pinpoint when those conditions have been met. Otherwise, the ERPA stays in a vacuum and no one knows whether it's going to kick in or not. So they have to have a specific time frame to be fulfilled to start with, and they cannot be entirely under the control of one single party. And if that is the case, it is always good that we add a language there just below the clause saying, listen, both parties here are obliged to undertake its best effort to fulfill those obligations. Otherwise, you're simply giving an easy way out for one of the parties that suddenly decides to give up the ERPA. So let's say it's no longer willing to get into this agreement, it has received a better price somewhere, and it simply just stays low and doesn't do its part in terms of filling out the condition precedent. So this is a risk that has happened quite often, of parties giving up the process. And this sort of clause will actually help out, making the parties more attached or even making the necessary efforts to meet all those conditions. For advance payment, which is something that Leslie was mentioning before, advance payment doesn't really figure as a condition precedent right here in the beginning of the agreement, in the beginning of the ERPA. But when advance payment is agreed between the buyer and the seller, at some point in the contract, you will see that the buyer will request that some conditions are met before the advance payment is made. So it's a different section, and you only mention here because they have the same legal nature as a condition precedent, to the sense that the advance payment will never be made unless the seller, the government, is able to meet the conditions for the advance payment. For instance, some buyers may require a bank guarantee, a letter of credit. Some buyers may require that the seller finds additional funding for financial closure of the project before they actually put some money in advance. Other types of requirements here could be that if the government has already some emission reductions that have been verified from previous vintages, and this agreement is about more recent vintages or future vintages, what it can do is ask the seller to segregate or to separate in a buffer account or something similar to that, on an escrow account, a number of credits or a number of emission reductions that have already been verified that could be used as collateral for a potential non-delivery of the emission reductions that are being negotiated under this agreement. So moving on from the idea of conditions precedent, so once those are met, the ERPA kicks in, it becomes 100% effective. And the primary obligation of the ERPA is to deliver and pay. Okay, and this deliver and pay actually has acquired many different forms throughout time. For instance, there is the option that we're just discussing right now, that is pay and deliver, meaning that the buyer will make an advance payment, so it will pay at some point in the middle of the process, and it will only get the emission reductions at a future date. So it pays first, but only get the product, the object of the agreement, at a later date. Now Normally those payments are made through milestones, so the buyer will set a number of milestones and will disburse this money in tranches, so as to avoid risk and make sure that the program is developing accordingly. Another option for this delivery and payment mechanism is the retirement and payment, which is a bit different from a sale structure, because the buyer is asking the seller to retire the emission reductions, so put them out of the system, and will then pay for it. That's an option that we have seen at a law firm at least a couple of times. And the risk with that option, where the buyer asks the government to retire and then only afterwards make the payment, is that once those credits are retired, they are out of the system, right? You cannot recover them. And if there is no payment coming after that, then simply you lost the credits and you didn't get the payment. So the suggestion for countries to negotiate this bit here is actually, well, you pay me first, right? And then I retire the credits. And then again, if the buyer does not trust the seller to do that, then the alternative would be to use an escrow account and an escrow agent, which is an intermediary that can guarantee that those processes are done simultaneously. Another option which is interesting is that the seller will deliver, the buyer will pay for it, but then there will be a request on the buyer that as soon as it receives the credit, it retires the credit. So it's no longer selling this credit as it would happen in a market that would simply sell on the credits in a chain of transactions. Other thing that sellers should also pay attention a lot is sometimes it gets a bit tricky as to whether the payment you have agreed is a net payment, meaning is free or net of any tax or any withholding or charges by banks. This is not always clear, and buyers tend to make this a bit confusing sometimes, so you have to make sure as governments and as sellers that whatever price you're negotiating there, this price is net of any deductions or withholdings coming from a foreign jurisdiction. So what is it that you're actually trading here? This is a very important thing because there are many options and many types of the same asset according to their evolution in the system. So where you don't have any specific methodology or standard agreed, for instance, it might be that the buyer and the seller agree that they will only deliver verified emission reductions. So that could be enough. That means that the seller is simply delivering a report which has been first validated and then verified by an independent auditor, which says that a number of emission reductions have been generated through a certain period of time. What is most common, at least until now, is that the buyers will want something that is actually validated, verified, and issued through a specific carbon standard. And that carbon standard could be the verified carbon standard, that could be the American carbon registry, the carbon fix standard, the gold standard. There are many standards out there that are able to produce the whole package in terms of providing, approved methodologies, validation, verification, and finally issuance. Another possibility is that this product that is being negotiated is not only an electronic issued VR, but also an electronic unit that is also tagged with a social standard label. So there are many standards out there that don't focus on emission reductions per se, but they focus on the different attributes, environmental and social attributes that those emission reductions bring. So that could be another object here. And finally, this is the case here in the last point, that some buyers, especially development banks, may not be so concerned about what type of standard you use. What they will request to you is that at least you have this verified, validated and verified by an independent auditor following a known methodology, and that you track those emissions through a registry system. So essentially, you can choose a standard, or you can copy a standard, if you will, as long as you have a third party validating this process, and then you engage a registry system to make sure that your units are being tracked there. So you tend to avoid double counting with that. The methods of delivery in an ERPA. Again, the methods of delivery always vary with the object you're trading here. So you can deliver the verification report, which is actually a paper, digitally or a physical paper saying, well, it has been verified. You can deliver the electronic unit, and that goes through a registry system. And it's something that governments have to have in mind, is that they have costs. And depending on how much emission reductions you're talking about, those costs can be big. So let's assume you're talking about selling 60 million tons of emission reductions, for instance, of an entire country or an entire region. If you think, I don't know, I think the issuance fees charged by registry systems are around 5 cents of a dollar. So we're talking about, what, $3 million, more or less, just to spend with the registry system. So this is something that governments need to have in mind, and perhaps also negotiate with buyers how they are going to cover these costs. Since we're talking about sale and purchase, delivery and payment, it's also important to talk something about the legal transfer of title, right? There are two options. There are two options here for transferring title through contract. One is that as soon as you have effectively transferred those emission reductions to the buyer will say that the title has passed to it. So from then on, the buyer is the owner of those emission reductions. What is actually best for the government here is to say in the contract that the title will only pass to the buyer once the seller has actually received the payment for those emission reductions, right? In that way, if the buyer receives the credits or the emission reductions and does not make the payment, you are legally entitled to choose between receiving the payment or receiving the credits back. That's an option you would have because you're still legally the owner of those emission reductions. So establishing the price is a very tricky thing. I think this has been discussed yesterday, and how to define the price for emission reductions, in particular in REDD+ programs and projects. I also don't have an answer to that. What I do have here is a list of characteristics that governments could take into consideration before defining what the price should or could be, or starting negotiating the price. First of all, not sure whether you can read this. So the seller should have a pretty good idea of what were the costs it incurred in developing that program. So knowing the cost is a very, very important first step to establish how much, should be sold in the future. Another thing that impacts on the price is looking at whether your emission reduction is only an emission reduction or whether it has additional attributes. So let's say it comes with social and environmental qualities, additional qualities that normally come with REDD+. And that has a value that fetches a premium to those types of emission reductions. Another point that is very important is whether the seller, the government, is granting a call option to the buyer. And I'm going to talk about a call option just some slides ahead. And a call option is normally deemed a right that is usually given for free to buyers as a standard in this type of market. But actually, they should worth an additional or an incremental value to the emission reduction, because normally call options are very flexible right and mechanism that only the buyer can access. So that's sort of a gift that is being to the buyer and normally not charged for. Another point that is interesting in terms of pricing emission reductions is how much the buyer is actually involved in the process, in the program. So is the buyer a partner? Is the buyer cooperating? Is it advancing payment along the way? Is it participating technically? If it's doing all that, it means that it's incurring risks and incurring in costs as well. So that justifies, that this whole risk is specified in the final price established between the parties. But a different situation would be where you don't have so much a long-term contract, but you have an ERPA where the government has already the credits issued or the emission reductions verified and is ready to transfer those to the buyer. In that situation, the risk that the buyer takes is very low. And that risk being low, the price should be higher. So those elements, I think, you should always take in consideration when defining or establishing or negotiating prices with buyers. As to the structure that the prices may have in ERPA, so prices may be fixed throughout the whole time, so it may be, I don't know, $8 per ton of emission reductions. Prices may be indexed to some sort of other asset, and that normally comes with a cap and a floor so that it doesn't vary too much. In the case of REDD+, this is more difficult because we don't really have a similar asset that we could attach to. But that was essentially the case when we had the CDM, for instance, and the CRs under the CDM were at some point in time attached to the values of European allowance with certain caps and floors. So that worked for some time, and that helped parties, keep the price floating according to the market trends at the time. Another option is to have both alternatives. So you can start with a fixed price, let's say for the first years, and assume there is some more clarity in the market, and you can find an index for that asset, for that REDD+ asset. You could then create a band and let the price of your product flow together with the market. So 2 things here. There are some positive and negative aspects. So when you have a fixed price, it means that you know how much money you're getting out of it. So your contract means you have an asset, and this asset means you have a certain volume of revenue, income, coming, let's say, every year. Why is that good? First of all, for your own planning, for your own financial planning, but also if you want to go to a bank and raise finance with that bank, the bank will want to see a contract where they can actually establish how much revenue you're getting from that contract. On the other hand, if your price is not floating together with the market, what happens is what normally happened before, also with the CDM, is that the buyers come and they offer $3 for something. The market changed, suddenly that something is worth $15, and the sellers don't want it to be in that agreement anymore. And the same happened on the other way around, where the price went down extremely, and then we saw buyers willing to get out of the agreement because they had a fixed price there, and the price was too high, and the market was offering way better prices for the buyers. So they were trying to find all the excuses they could to get out of the agreement. And that's sometimes very easy for the buyer because those ERPAs are full of obligations for the sellers. It's a whole list of obligations that are imposed on the seller. So if the buyer wants to get out, depending on how you have structured ERPA, they will find an easy way out. So talk about obligations that are imposed on the seller. I have listed here some of them. Mainly related to the implementation of the project. So buyers will normally require that the government implements the program in accordance with the program description and the agreed methodology with the buyer. Okay? They will also sometimes require that the seller obtains some sort of social stamp that validates and verifies that, you know, this program is not only bringing out emission reductions, but also creating other benefits in terms of biodiversity, in terms of benefit sharing systems, creating jobs, increasing the quality and quantity of water, for instance, all those things that are not necessarily valued like RED plus emission reductions are valued, but they still are important. Another request is that the seller will actually implement a benefit sharing scheme. So it will distribute the revenues to those that are actually performing the environmental services on the ground, that they ensure validation and registration, and that they achieve certification and issuance. Those are very, very common obligations that are normally imposed on sellers in long-term contracts. And here what governments can do to sort of defend themselves a bit and not be in a very, let's say, disprivileged position is to use languages such as taking reasonable steps, undertaking reasonable efforts, or best efforts even, to achieve those things. I mean, I think the government should never really promise to achieve an end result for all of this. It can try its best efforts at most, but promising to achieve, it means that as soon as you have reached a certain date and this has not been met, then you are in default in the contract. Whereas if you say that you're taking reasonable steps, or best steps, if you will, then it is harder that, you know, to demonstrate that you're not doing anything. And this is also not just a question of, you know, techniques to negotiate. It's also the case that achieving validation, achieving verification and issuance is something that is complicated, especially if you're talking about new methodologies or new standards that have not been tested out there yet. So the process here is very complicated and very complex. It doesn't mean that you actually have that you go through all this and that you will be successful at the end. So whenever you have a social standard coupled with your emission reduction, whatever that social standard is, it fetches a premium. So you should remember that, you know, if your emission reductions have additional attributes, it will worth more in the market. On the aspect of benefit sharing schemes and safeguards plans, my opinion is that this is reasonable, that this is asked from the government, that they do have those mechanisms already set into their systems. What you should be concerned of is how much this system is actually regulated in the contract. Because if the wording they use in the contract is too restrictive, you know, if the buyer is intervening too much on how you set up those schemes, it means that any sort of deviation from that, you'll be in default. So I think that the common or the main message here in terms of what is reasonable to accept and what is not reasonable to accept, first of all, is to determine how much the buyer is involved in all this. Right? If the buyer is looking at a government and say, okay, I only want to buy credits from you, I don't want to invest, I don't want to pay an advance payment to you, I don't want to contribute with technology, I don't want to help out with validation or anything else, I just want the emission reductions at the end. I would say that in those cases, the rights that the buyer should have under the ERPA should be very limited. Right? But on the other hand, if the buyer is proposing to act as a partner in the process, then yes, because the buyer has some skin in the game and you're sharing both the risks. So that would make sense that you would assume more obligations as a seller under the ERPA. Continue on the duties and obligations. One important thing in the ERPA is to establish how the parties will communicate with the chosen standard. And this is very important because once the parties have defined the focal point focal point only who will be able to tell the standard what to do with the emission reductions when they are created and how those emission reductions will be allocated. So buyers, of course, want to be in control of those emission reductions because they're actually buying it. But if the buyer assumes that role of focal point, that may create a number of difficulties to the seller. So, for instance, in case of a dispute, a legal dispute on the contract, that means that the seller will never be able to shift or move those emission reductions that still belong to the seller unless he gets an authorization from the buyer. And that's a very problematic thing. The other thing is that when the buyer assumes the role of a focal point, it will also push away the interest of other buyers, because other buyers will look at that relationship and say, okay, the seller has no control whatsoever for those credits. So the fact that I will eventually receive credits from that project depends on another buyer, a third party, actually accepting that this takes place. A second important thing is the use of predetermined standard. So it's normally that buyers will try to ask sellers to help them out in converting whatever emission reductions they sold to the buyer into a different standard that may be potentially accepted under compliance regime. So it is important here that you think that this obligation to assist is not more than a cooperation, so you don't have an end result obligation to make that happen. And whatever costs that conversion imply should probably be borne by the buyer. I will have to move a bit faster because we have some pressure here with time, and I'm going to move quickly to some other more important aspects, which are more important than communication to the general public, which is, well, call options very quickly. Call options that are right, that are given to the buyer, actually that are sold to the buyer, should be sold for a price. That means that the buyer that has a call option, it has the ability, but not the obligation, to buy emission reductions from the government. So that's a very good flexibility that is given to the buyer, and needs to be very well regulated. First, it needs to be charged for. You also need to know how many times the buyer is able to exercise that call option. So how many times the buyer would be able to buy those credits, which are called additional emission reductions or additional credits. You have to define the price for that. And you have to define as well to which vintages are you talking about. So are you talking about call options within the crediting period that you're actually negotiating your credits? Meaning, let's say you're selling 8,000 emission reductions from a certain period, but you actually produce 100,000. So there's difference. This 20,000 could be something that is given as a call option to the buyer. So all these things must be very well defined. An option for the seller that does not want to give a call option to the buyer is to change that for a right of first refusal. And that means that the seller, the government is not really forced to sell to the buyer, but if it decides to sell additional credits, it has to offer the same commercial terms to this buyer. So this buyer is actually able to match the commercial terms from third parties that are also willing to buy credits from the government or from that seller. Getting to the final bits here, just to finalize the presentation. Termination. Termination in the ERPA is very important. There are two ways you can actually understand termination. One is non-default termination for events that cannot be attributed to any of the parties. So normally you're talking about force majeure events, which is, catastrophic events, nature events, but may also include registry failure. You're talking about mutual agreement of the parties. They may terminate the agreement by mutual agreement. You're talking about the actual settlement of the transaction, or a supervening condition which is beyond the control of the parties. For instance, a material change in law. So the law that created the RED system is overruled, no longer exists, so the RED system in that country can no longer function. So that could be a fact that would result in non-default termination. For default termination, normally we have those items there involves a material breach. And then again, you need to be careful because those airports have too many obligations on the seller. So always try to frame obligations such as reasonable efforts or best efforts, right? That helps a lot. The main two factors for termination are non-delivery, meaning that either the volume that was promised to be delivered was not delivered, or that it was delivered but delayed, so not on the right time and specific date agreed between the parties. On the side of the buyer, the main aspect is payment default. What happens on default termination? Normally, the standard is if there is a default and this default is not a result of an intentional breach, of a willful misconduct or a gross negligence of the seller, of the government, then what happens is that the other party is simply able to terminate the agreement, and if there was an advance payment, to request and recover that advance payment back. Okay? In some cases, when we talk about intentional breach, so let's say that the government has the emission reductions but simply refuses to deliver, then the buyer will try to impose liquidated damage in those cases. And for that, although this is unlikely to happen, it's also good to have this regulated in the contract. So you should always remember to cap your liability, establish a maximum amount that you pay in case of default in the contract. Otherwise, your contract, which is an asset, can turn into a liability, right? And the other thing is, avoid, whenever you see that expression in the contract, indirect or consequential damages, you need to scrap it out, right? Because that means that you're not talking about the liability of your buyer, but you're talking about the liability of the buyers of your buyer. And that can be endless, okay? Just to finish up, governing law and dispute resolution. These contracts, unfortunately, they are by standard normally governed by English law, okay? When you're dealing with countries, it might be that the country needs to apply its own domestic law and its own courts, so that will be a problem of negotiation with the buyer. But what we see normally is English law with arbitration somewhere in England, somewhere in the Netherlands, or even in the US, okay? What is the problem with this? Cost. It's very costly to hire English lawyers. It's very costly to hire and pay for arbitrators. Sometimes it's free arbitrators. They're flying everywhere. They cost money, and it's costly to travel there and translate all the documents. So this is something you should start thinking carefully when negotiating the airports, and try the most you can, if not to use your own courts, at least to bring arbitration very close to you, okay? One thing that may mitigate a bit the process and avoid a binding dispute resolution process is to establish in the airpass some phases for trying to solve the issue before they get to dispute resolution, which is expert determination, so appointing some technical guy that understands about the issue and that will be able to try to solve the problem, or even mediation, which functions more or less the same way, but mediation normally has someone that has a legal background and will help the parties to find a compromise, even though this is not binding, okay? But usually when the parties accept this, then they will stick on to their commitments, and they tend not to go to dispute settlement. That is a binding procedure, and which is very expensive. I'm sorry that I had to rush with all this. ERPAs are very long documents, and time was a bit short. I hope it was not too fast or too technical.
Other contracts under any other sort of jurisdictional arrangements, there's often good reasons for doing it because of clarity. But I'd like to get your thoughts on the alternatives, because it seems like you could get yourself into quite a mire if you ended up with jurisdictions other than something that you were familiar with. But the other 2 points, I wondered whether you have ever seen tradability of the call options as distinct from the ERPAs, because in some versions of contracts, not in carbon markets, but you can separate the option from the underlying contract and trade the option. And I think if that was available, it would be much more attractive as an instrument and easier to price, because you'd have a market there to price, and the government would be likely to more able to charge a price for the option as well, because it's tradable. So it's not bound to that contract.
Yeah.
And then the other thing I wondered was, you talked a lot about cost plus pricing. And I would say in a competitive market like we have at the moment, where you've potentially got oversupply, you may not want to just look at cost plus. Cost plus is one view. In competitive markets where I've worked in before, you certainly want to know whether you're making a profit or a loss, but you may take a more of a portfolio-wide approach to pricing, where on some assets or sub-components of your portfolio, you accept that there's going to be a loss. But you're making profits elsewhere, so in net, you're profitable and competitive and able to sell it in the market, particularly if you're competing against substitute offset classes like maybe cook stoves or something like that. So I'd kind of be quite interested in hearing your response to those 3 questions. Sorry, it's quite a long.
Okay, let's start.
I think those are pretty technical and we're a little bit late. Maybe you guys could do that. Not that they're good questions, but we're kind of running late.
Yeah, sure.
Without being overly rude, maybe you guys could take that one offline.
Sure.
Okay, those are great questions though. That way we can get everybody to get a chance to talk. So wherever Mario is or Hector. Okay, move on. Sorry, Thiago.
Oh, that's fine. We can talk later and discuss.
Are you here till tomorrow morning?
Yes. Yeah.
Lo siento.